Welcome to Intellectual Property and Copyright, an instructor's guide to the law. This learning module is designed to give instructors a better understanding of what is and what is not acceptable use of the intellectual property of others, specifically regarding educational use. Intellectual property, also known as IP, is a term referring to information, ideas, and other forms of expression, essentially the product of the mind or intellect. In society, there is a common belief that laws for the protection of intellectual property will allow a creator or author to use or exploit his or her works, usually for monetary gain, and that this is good for society because it will help promote innovation and invention in the arts and promote disclosure and distribution of this innovation to the public. Likewise, the body of knowledge, invention, and creative works that society considers to be part of our common heritage should be free for anyone to use. We refer to such works as being in the public domain. Depending upon the type of intellectual property, there are different time periods and other rules for when something becomes part of the public domain. There are different classifications that depend upon the nature of the intellectual property. There is trade secret, patent, trademark, industrial design right, and copyright. Trade secret protects confidential information related to trade or businesses. Trade secrets can be protected indefinitely, as long as the owner of the information treats the information as secret. A patent protects inventions of a technical nature. They are limited in time to 20 years. The idea is to allow inventors to profit reasonably from their inventions by giving protection, but also allow the inventions to become public domain after a time for the benefit of society. Trademark protects distinctive signs or marks used to identify or distinguish a product or service offered by one business from another. It allows companies to protect their brand by preventing other companies from selling their goods or services under similar names or symbols. An industrial design right or design patent is similar to a patent, but it protects the design element in a manufactured article. Copyright is the part of intellectual property law that we as educators most often encounter. It protects original creative works that are fixed in a tangible medium of expression. It protects literary, dramatic, musical, and artistic works like poetry, novels, movies, songs, computer software, and even architecture. It is important to note that copyright does not protect facts or ideas. It protects the expression of facts or ideas. Ideas are not copyrightable. An easy way to think about how copyright works is to think about it like property, like land is considered property. Like real property, intellectual property can be sold, given, left to an heir, divided into different parts, and protected from trespass. And like land, it can be subject to expropriation for use that is deemed to be in the public interest. If you've ever gone to the beach in a more residential area, you will find beach access pathways. These pathways were originally taken from the property owners on either side because it was deemed in the best interest for the public to have access to the beach. There are many categories of creative works protected by copyright law. Literary works is one category that includes books, manuscripts, pamphlets, poetry, reports, and even computer programs, because computer programs consist of code that can actually be written out. Another category of copyright is performing artworks. Performing artworks are those that can be performed, like dramatic works, pantomimes, choreographic works, motion pictures, and other audiovisual works. Visual artworks are pretty much anything that's visual that's not a performing artwork. Advertisements, bumper stickers, greeting cards, drawings, paintings, fabric patterns, wall covering designs, patterns for sewing, original prints, reproductions of paintings, paintings themselves, technical drawings, architectural drawings. All of these fall into the visual artworks category. Serials and periodicals are an exception to literary works. They have their own category. Newspapers, magazines, newsletters, etc. Mask works are patterns or images used in the manufacture of semiconductor chips, computer chips. Then, of course, there are sound recordings. These are works that result from the fixation of a series of musical, spoken, or other sounds. These recordings are called phonorecords, and can be tapes, records, CDs, etc. Recorded music that is part of a motion picture or other audio-visual work is copyrighted along with the film, under the performing artwork category, not separately as a sound recording. Copyright is not simply the right to copy, it is a bundle of rights. These rights include the right to copy, the right to create derivative works, the right to distribute copies to the public, the right to perform the work publicly, the right to display the work publicly, the right to perform the copyrighted work publicly by means of a digital audio transmission. That's sound recordings only, and that's a recent addition. Let's look at these individually in more detail. The right to copy is obvious. The copyright owner has the exclusive right to make copies or to reproduce copies of the work. The right to make derivative works is also the exclusive right of the copyright owner. A derivative work is a work that is derived from another. An example of that would be a translation of a book, a movie that is based upon a book or a comic book, or a song that has portions of other songs sampled within it. The copyright owner has the exclusive right to distribute the work. Anyone who does not own the copyright does not have the right to distribute the work to the public. The copyright owner has the exclusive right to perform the work publicly. This is not just live performance. For example, it also includes the playing of a song publicly from a CD or radio transmission, or the performance of a play on television. If you are playing a CD over a boombox on the beach without the copyright owner's permission, technically you are in violation of copyright law, and this is considered infringement. Likewise, it's the exclusive right of the copyright owner to display the work publicly. This covers photos, reproductions of paintings and drawings, visual artworks. The right to perform the copyrighted work publicly by means of digital audio transmission, for sound recordings, is similar to public performance mentioned earlier, but is specific to digital audio transmission. This came about in the 90s to address digital streaming. I want to go back to public performance or display. The Copyright Act refers to public performance or display as performing or displaying a work at a place open to the public, or at any place where a substantial number of persons outside of the normal circle of a family and its social acquaintances is gathered. What this means is the law considers performance or display in a classroom as a public performance. In order to deliver a very relevant education, instructors often want to give real-world examples. If these examples include copyrighted works, then the instructors will need the right to copy, the right to distribute works to the students, or the right to perform or display works for the students. When does copyright come into existence? Well, for an expression of an idea to be copyrightable, it must be fixed, meaning the work must be written or recorded in some physical medium. Once it is fixed in a physical medium, copyright immediately comes into existence. The small mark with the C with the circle around it and the word copyright, followed by the year it was copyrighted and generally the author, is referred to as copyright notice. Copyright notice is not necessary. It is a good idea to remind people about copyright laws, but it is not necessary. Do not assume because there is no copyright notice on a work that it is public domain. Infringement is the unauthorized use of copyrighted material in a manner that violates any of the copyright owner's rights. The penalties for copyright infringement can be quite severe. You could have a award of damages based on fair market value. In other words, if, for example, you made thousands of copies of somebody else's CDs and sold them yourself, you could have a award of damages for the loss of him not being able to sell those same thousands of copies. There are also statutory damages that range from hundreds of dollars to hundreds of thousands of dollars. And of course, injunctions to stop you from infringing, court-ordered destruction or seizures of infringing copies. There's also a potential of criminal penalties if the infringement is willful, and of course, court costs. So with all these rules regarding copyright and potential penalties for infringement, how does an instructor whether in the classroom or online, use real-world examples. Well, one way would be to get permission from the author, but sometimes this is extremely difficult and extremely complicated. The law has a provision that makes this possible in certain instances. You can think of copyright law in some ways as similar to regular property law, like real estate law. I mentioned the beach access earlier. In that example, the taking of someone's real estate would normally be an infringement on a person's private property rights. However, the government's power of eminent domain allows the taking of private real estate if it's for public benefit. The law has a similar provision with regard to intellectual property. Under certain circumstances where it could benefit the public, use of copyrighted material by those other than the copyright owner is permitted. This is referred to as fair use. Essentially, fair use is a limitation on a copyright owner's rights. It allows the use of copyrighted material without permission from the copyright owner. But it only applies if the use is limited and transformative, such as for commentary, criticism, or parody of a copyrighted work. The fair use provision is what allows educators to use copyrighted material without getting permission. But there are restrictions on the use, and the restrictions are sometimes not entirely clear. In an infringement case, the court will make a decision based upon several factors. The combined weight of these factors will guide the court in making their decision as to whether a use is fair. These factors in determining fair use are the purpose and character of the use, the nature of the copyrighted work, the amount and substantiality of the portion used in relation to the copyrighted work as a whole, and the effect of the use on the potential market for the copyrighted work. Let me discuss the purpose and character of the use. Strictly commercial use of a copyrighted work would suggest against it being considered fair use. Educational use of a copyrighted work would lean the court toward fair use. But educational use that is for commercial purposes may not be excused by the fair use doctrine. Also, is the use transformative, meaning is the new use of the work significantly different? Let me give an example. If you own a large company and you have a need to train multiple employees in a specific procedure, and you find a book that explains that procedure well, and you buy one copy of the book and then make several copies of it for your employees, yes, that is educational, but you're doing it for a strictly commercial purpose. Also, the work is not transformative. It was an educational manual, and you are now still using it as an educational manual. So that would not be considered fair use. The nature of the work can also be a factor in determining fair use. The use of a factual work, such as reprinting a portion of a scientific article, is viewed more favorably than the use of a fictional work. There was more creativity in the fictional work, whereas the scientific work is based more on facts and has less creativity involved. A very important factor in this determination is the amount of the copyrighted work used. Using the entire work or a substantial amount weighs heavily against a fair use defense. Using a small portion of work specific to the educational purpose would weigh more in favor of the fair use doctrine. The effect of use on the potential market for the work. If a use could reasonably be seen to damage the copyright owner's ability to profit from their work, this would weigh against a fair use defense. Let me give a few examples to try and clarify this issue of how all of these factors are weighed together in determining fair use. Let's say you have a situation where a school is selling a reprinted scholarly article in their school bookstore. These are copies made by the school and sold in the school bookstore. Well, the fair use factors that a court would consider if an infringement case was brought against the school would be the purpose and character of the use, the nature of the work, the amount of the copyrighted work used, and the effect of the use on the potential market. The purpose and character of the use. Well, the use is educational. That is favorable toward a fair use defense. It is a for-profit institution. That is not favorable. The use is directly commercial. They are directly profiting on the sale of these copies. And the use is not transformative. It's a scholarly article and they're using it as such. Let's look at the nature of the work. Well, it's a nonfiction scholarly article, so this is favorable, but again, it's not a transformative use. The amount of the copyrighted work used is not favorable. The entire article is copied and distributed. And let's look at the effect of the use on the potential market for the copyright owner. The students are purchasing it from the school, not the copyright owner, so they're not likely to go purchase another copy from the copyright owner, so it directly affects the copyright owner's right to profit off of his own work. Let's look at another example. Ongoing distribution by an instructor of an entire scholarly article. Now, this is not for sale in the bookstore, so there's not a direct profit off of it, but the instructor is distributing an entire article. Well, the purpose and the character of the use is educational. It's not directly commercial, but it is a for-profit institution, so it is benefiting the institution. The use, again, is not transformative. It's a scholarly article. Although the nature of the work is scholarly, the amount of the copyrighted work used is the entire article. The effect of the use on the potential market, again, the students may not purchase the article now that the teacher has given it to them. So this should definitely be considered infringement, and the fair use defense would not hold up. Here's another example. Copying and distributing a 3-sentence quote from a 200-page textbook. Let's look at the purpose and character of the use. Well, it's educational. That's favorable. The use is not directly commercial. It is a for-profit institution, however, and the use is not transformative. The nature of the work is nonfiction, so it's not technically as creative as a straight fiction work. So that is slightly favorable. It is a very small percentage of the work that is used in comparison to the whole 200 pages of the textbook. And if it is properly cited, this would weigh heavily toward the use being fair. And because it's so small, it has little or no impact on the market for the sale of the textbook. Nobody's going to not buy the book because they were read 3 sentences out of it. This would most likely be fair use. Here's another example, playing of a song in the classroom during a break. Let's look at the fair use factors. The purpose and character of the use. Well, it's a for-profit institution, which leans against it being fair use. Also, the use is for entertainment, not education. It's not transformative at all. The nature of the work is extremely creative. It's a straight creative work. And the amount of the copyrighted work used. The entire song is played in the classroom. The effect of the use on the potential market has little or no impact. In fact, somebody might even hear the song and want to go buy it. So that might be considered favorable, but the not favorable side of this so outweighs that. This would not be considered fair use. Here at the Los Angeles Film School, on campus, we pay licensing fees that enable us to play music. Musicians sign with performing rights organizations who offer licenses to institutions like ours and restaurants, bowling alleys, airports, stores, things like that. So we are actually paying licenses on our campus to be able to do this. That's not considered fair use, though. That's just considered permission from the copyright holder. Our license is to be able to perform music in the classroom. That is not for making copies and distributing. Here's another example. The playing of the bridge of a song in a musical arrangement class. Well, the fair use factors, the purpose and character of the use. The use is educational. They're talking about musical arrangement. The use is not directly commercial, although it is a for-profit institution, and we do benefit by playing this because it's relevant. The nature of the work is entirely creative. The amount of the copyrighted work used, well, it's a very small percentage of the work that is used. It's just the bridge. And the effect of the use on potential market. There is little to no impact on the market for the sale of the song, so that is favorable. This does lean heavily toward it being fair use, but not entirely. This one is difficult. This is the problem that we run into with the fair use doctrine. Boundaries are not entirely clear. To get a definitive answer on this, you would have to go to court, but it does lean very favorable toward this. This is probably fair use. Here's another example. Playing the class the movie The Big Sleep in its entirety as an example of the film noir. Well, let's look at the purpose and character of the use. It's educational. The point is to give an example of a certain film genre. It's not directly commercial, although we are a for-profit institution, and it does benefit us. The nature of the work is entirely creative. It's a fictional work. In this case, the amount of the copyrighted work used is the entire film, and the effect of the use on the potential market could be negative because students may not rent or purchase the film now that they have seen it in class. So this would be pretty definitely not considered fair use. Okay, what about just playing two scenes from The Big Sleep as an example of film noir? Well, the purpose and character of the use is educational. It's not directly commercial, although we're a for-profit institution and it does benefit us. The nature of the work is entirely creative. The amount of copyrighted work used, however, is a very small percentage of the film. And this would probably not be a big effect on the potential market for the film. This would most likely be fair use. But again, there are no clear definitions. There are not a specific number of frames or scenes you can play from a film. Due to the creative nature of these works, there is no way to totally define all the different scenarios that could come up legally. So that's why there are not very bright lines as to what you can and what you cannot do. So while this probably would be considered fair use, there is no definite here. Okay, what about playing the movie The Big Sleep in its entirety as an example of story? Well, the purpose and the character of the use is educational. It's not directly commercial, but we are a for-profit organization, which is not favorable. The nature of the work is creative. You'd be using the entire movie, but you would have to in order to explain the story, wouldn't you? This would impact on the potential market because the students may not rent or purchase the film now that they have seen it in class. So how do you talk about story without playing the entire story? Well, you could choose alternatives. In this case, it might not be a good example to use for story without permission. It's the intent of the Los Angeles Film School to fully comply with copyright law. Copyright is especially important to us as we are training students for work in fields that rely on these rights for their very existence. And again, because of the nature of creative works, there are no clearly defined rules, such as a specific number of words one can copy or a number of notes from a song or minutes from a film one can use, that define fair use. There are only guidelines. Consider them very carefully. What if it's pretty clear that it's not going to be fair use if you use this in the classroom or online for instruction? Well, we have to look for alternatives. Look for ways other than using copyrighted material to support the lesson. This can be difficult, but we need to avoid using unlicensed copyrighted material. You could create new material. You could use materials for which the school owns the copyright. You could ask for permission from the copyright holder to use the material. Very often, copyright holders feel honored to be used in an educational environment. Also, look into using Creative Commons licenses. Go to creativecommons.org for more information. Creative Commons is a licensing structure that was set up to allow copyright owners to give various licenses for free depending upon the use. They may require attribution, they may allow it for free use, but it's a very interesting concept, and there's a lot of quality work under the Creative Commons license. You can also link to work on the internet. This we use a lot, especially in the online environment, because the online environment creates even more problems with copyright, because almost every use of it requires a copy. If we put a work onto the LMS, we have to make a copy, and when a student downloads it, that creates another copy, and we are also de facto distributing it to the students. So we're constantly running up against potential copyright violations. That's why the fair use defense is so important. Because if we want to have the students listen to a specific song for some reason, or watch a film in its entirety or a large portion of it that would not be considered fair use, or read an article, for example, we can't be taking those works wholesale, because the amount and substantiality of a work is so important to the fair use defense. That's why linking is such a great opportunity for us, because the work exists somewhere else and we are just sending them to that link. Or, in the example of music, you could send them to a YouTube link, or you could ask them to open a Spotify account so that you can specify a specific song for them to go look at, for which they would get a license through Spotify. When you are linking to material on the internet, be very clear about attribution. It's important that the person viewing it can discern between content that the school created or owns and the separate outside content. In this example, you could be asking a student to read a specific movie review. It's important that you don't just have the word review as the link. You should be clear that you are being taken to a different location. Mention the copyright holder's name in the text directing the students to the link. For example, you could say, "Please read Peter Travers' August 13th review of the film Blinded by the Light at this link." Even better, avoid deep linking. Deep linking means linking directly to a work one or more pages deep in the website. Even the above example is considered deep linking because you're not going to the upper level of the website. It would be better done. Please go to the movie review section of rollingstone.com and read Peter Travers' August 13th review of the film Blinded by the Light. This way there is no confusion as to who owns the work. I hope this helps clear up some of the fuzzy nature of copyright and how copyrighted works can be used in an educational environment. If you need further information or are confused whether or not to use a specific work in your course, please contact your program director, or you can contact me, Andrew Mackenzie, at amackenzie@lafilm.edu. That's amackenzie at lafilm.edu. Thank you.